My lord, we have filed one writ.
Chaudhary, sorry for
No,
being
no, sir.
10 minutes late. Meetings don't seem to end. The
My
morning
lord,
and
I am
evening.
seeking a permission
Yes.
to move a petition tomorrow, my lord. There's urgency. A petition filed on behalf of the BSNL, my lord, in a transfer posting matter where the tribunal has passed a stay order against which we filed an IA for vacating that has not been done. Instead, it has been fixed for hearing. So, my lord, there is urgency in the matter tomorrow, my lord.
Well, two matters, my lord. One is PIL, my lord, the lawsuit has heard the matter, directed us to look into
Achha,
some
please
case.
bear in mind, this bench is for only 2 days.
Yes,
We have not
on Monday. Let it come up on Monday. Two matters.
My lord,
For
permission,
correction of the names.
my lord, permission, may I mention a matter, my lord, writ appeal to be listed tomorrow, my lord, there is urgency in the matter, my lord,
Tomorrow for what?
for hearing, my lord,
Tomorrow not.
admission hearing, my lord.
Monday.
My lord, I have come from Delhi, my lord, if my lord can accommodate me tomorrow.
Enjoy your time in Guwahati. Come again. This is a temporary bench for 2 days.
My lord, may taken up tomorrow, my lord.
No, sir. Monday you want, we can give you.
Huh?
Yes, Monday. Yes, next matter.
May I please, my lord, with the consent of the officer, I beg to mention item number 39, my lord.
Hmm.
Item number 39.
Item number 39.
Yes, my lord. And the personal difficulty on the part of contacting council, my lord.
Yes, what do you want?
My lord, after vacation, my lord.
You have for the,
APDCL, my lord.
you have informed the other side
Yes, my lord, the other side.
on the request of non-standing council APDCL appearing to the respondents made with the consent of the other side. This matter stands adjourned. List after the upcoming puja holidays.
I'm deeply obliged.
With his lordship, lordship, I beg to mention item number 6, your lordship, lordship, and the agenda matter for the day, your lordship.
Item number?
6, your lordship,
Yes, what do you want?
adjournment for the day, your
You have
lordship.
for the petitioner.
I'm for the petitioner, sir.
On the request of learned counsel for the petitioner made with the consent of the other side, this matter stands adjourned for 4 weeks. List accordingly.
Obliged, my lord.
May Mr. Lordship, with the consent of other side, I beg to mention item number 2 of the today's list. So Lordship may kindly fixed in the month of first week of November, if possible.
Lordship, I am for the appellant. Lordship, if it can be taken up before the puja, like lordship.
Agree on a date before puja.
On 1st of October, lordship, it is
On the request of Mr. S. Das, learned counsel for the respondent number 12760, 12760, made with the consent of Mr. R. K. D. Chaudhary, learned DSGI, appearing for the appellants. Admission hearing of this matter stands adjourned till 1st of October 2024. List the matter accordingly.
May I please, Lordship? With the consent of the respondent side, Lordship, I beg to mention item number 43, 44, and 45. Discussion and praying for adjournment, Lordship.
43,
44 and 45, Lordship.
you are for the,
Appellants, Lordship.
right, on the request of learned counsel for the appellant made with the consent of the other side.
Lordship, interim order is there, Lordship. That may be.
You have taken consent of other side.
Lordship.
Yes, sir.
Hearing of these matters. This is a hearing or admission hearing?
Hearing, my lord.
Hearing.
Hearing of these matters stand adjourned for 4 weeks.
Interim order is there, my lord. That may be allowed. to
Orders,
continue.
if any, will continue until further orders.
I'm obliged.
Yes.
My lord, can it be on Tuesday, my lord, on 10th instead of Monday, my lord?
No, what is that you want, Mr.?
My lord, instead of Monday, my lord, Tuesday, my lord, it can be listed, my lord.
What do you want? Listing for what?
Fresh appeal, my lord, writ appeal.
Fresh street appeal.
Yes, my lord.
What is the urgency?
My lord, urgency is that it is a termination of contract, my lord, and there are the condition in the bid document that if my contract is terminated in last 2-3 years, I am not able to participate. My entire business has been, my lord, closed, my lord. I am not able to participate for last 4 months, my lord. In any of the bids, my lord. I am a civil engineering.
So it is first listing.
Yes, my lord, fresh matter, my
You
lord.
should have said that. You said admission hearing.
I'm sorry, my lord, I am from Delhi, so I could not.
No, then that's, if it is first listing, you have it tomorrow.
First listed, my lord. Deeply, deeply.
Daily list for orders, item 1.
Yes.
Because against the order, a review petition was filed before the division bench, and that review petition was also dismissed because there was a delay of almost 523 days. So this order stands today. Page 23 is the operative portion of the order. Last paragraph, my lord, we accordingly set aside. my lord. And they have not yet complied with the order.
The termination of service.
Yes,
How many appellants?
two. The, in appellants were five. In the contempt petition, two petitioners have come.
Yes.
My lord, I am appearing for respondent number one, my lord. Day before yesterday, we have filed our affidavit, my lord. We need some time to file our affidavit.
My lord, this
My
contempt
lord,
petition
because, my
was
lord,
filed on 29/11/2018. And the order of the court is of 10/7/2018.
And what about the respondent number two?
Well, on the last occasion, they said that the officer has been changed. We implemented the new party, and I think someone had entered appearance on the, yes,
Who is the new incumbent?
new incumbent.
Narayanpur and Suranjana Senapati. Narayanpur respondent number one and Suranjana Senapati is respondent number two.
So who is appearing for respondent number two?
My friend said,
My lord, my name may be recorded, ma'am.
So this order was passed in.
10/7/2018.
My lord,
And it has not been.
true,
implemented.
my lord, they have accepted the accommodation as per my lord cabinet decision, my lord.
Hmm.
Petitioner has accommodated the, my lord. So, my lord, we need to file our affidavit, my lord. Let us respond.
Earlier respondents have already filed their affidavit in this case.
So we'll give them 10 days time to file affidavit, but on
Already
that
affidavit-
day,
Okay. Yes.
Cabinet
Affidavit in
decision is
opposition has
dated-
been filed by the respondent number
when
two.
was the cabinet decision taken?
In the year 2021, they have been accommodated, my lord, as a tutor, my lord. They have forgive their benefit, my lord.
No, madam. We did not have a choice. They compel us to take the appointment of the tutor. That also they said that your appointment is illegal and irregular. In spite of the division bench order, my lord, we can't go without any job. This order, the division bench order is yet to be complied by them.
No, but if you have already been appointed.
No, I've been appointed as a tutor, not by that original appointment, which has been, my termination has been quashed. That they have not called it back.
They have.
They had filed a review petition giving all sorts of excuses. Here also, the respondent number two has filed. Those excuses are not tenable in view of the order that review petition has already been dismissed.
When was the review petition dismissed?
It was dismissed on the ground of delay. It has a title.
Let us see the order, review petition.
Online is a discipline. Review petition number 2287 of 2020.
Is the
In
order
read,
there?
in read appeal number 304 of 2014.
What's the order?
That order is not uploaded, my lord, but we are there when it was dismissed.
Order is not uploaded.
Order is not- Because it's a one-line order, because the IA for the condemnation of delay was dismissed, because delay was more than 500 or something days. And they were taking time in this case all along, saying that review is pending.
But 10 days time may be granted, my lord, will respond.
All right, if they don't file within 10 days, we'll consider directing personal appearance. Heard Mr. B.D. Kaur, learned senior counsel appearing for the petitioners. Also heard
PK
Mr.
Bora, my lord.
P.K. Bora, learned counsel for the respondent number one, who submits that he has instructions to appear for the respondent number two also in this case, and prays for 10 days time for filing affidavit, bringing the stand of the respondents on record. Full stop. Responding to the above, Mr. Kaur submits that taking the plea of pendency of a review petition, which has eventually been dismissed by the division bench, comma, the respondents have availed adjournment in the matter on numerous occasions, and therefore no further time be granted to the respondents to file affidavit. Instead of having heard the learned counsel for both the sides and considering the nature of controversy involved in this proceeding, we are inclined to grant 10 days time to the respondents to file their affidavit Accordingly, the respondent.
Subject to your 13, my lord.
It is
13 or
stand
19?
on record by filing affidavit on or before 16th of September 2024. Let this matter be listed again on 18th of September 2024 as a fixed item. It is made clear that if no affidavit on behalf of the respondents is filed on or before the date fixed by this court, on or before the date fixed above, this court will consider directing personal appearance of the respondents so as to assist the court in the matter. Yes, take-
Obvious, my lord.
We are blessed.
Consider the need for directing.
Item 3, prohibition.
Minute your loss. What you lost, kindly see the order dated 1/2/23, my. And thereafter order 3/3/23, two orders, my. Okay.
Is what is,
In pursuant, they filed their one affidavit, my your loss will find in page. Page one
so
fifty-two.
what is the prayer in the writ petition?
They are matter inclusion of non-tribals in the tribal.
It's a political exercise.
This is the case.
No, the high courts should not get into involved. in
Matter
this
the
offense.
160, as your lordship can say,
Hmm.
they must show that matter because they are primitive, they do not have any education, other things at all. If that's satisfied, I have nothing to say.
That's
on.
correct. You may be correct.
Yeah.
The cause may be genuine.
Right.
But the forum is not the court. These are all political decisions should be debated in the floor of the assembly, and this is not
They
for
have
the high
submitted-
court to say who should be included, who should not be.
Only
should
question
be
matter whether the section might have the provision which allowed them to do it, whether that is satisfied or not. That things your lordship. If it is, I have nothing to say, my. They filed an affidavit, but in terms of that order, my lord, that your, if page 152, your lordship will find.
You are referring to order dated
1/2/23, my lord.
These two orders I have annexed
Yeah.
along with my affidavit.
They
which
annex
your
also,
lordship
ma'am.
has before your lordship.
If you can take up the affidavit, page 152.
Both the orders have been
Yes,
separately annexed.
both the orders are enforced.
Yes. These PILs are.
That is my lord, but only my lord, your lordship, that's 160, suppose,
Diluted the PIL jurisdiction.
that's true, my lord, but 160, suppose
Who
one.
then who is responsible, Mr. Chaudhary?
Question, my lord, these areas were only for the protection of the tribal peoples, my lord. It negates, inclusion of non-tribal negates the impact.
It has already been mentioned. The cause may be genuine, but is everything, can everything be sorted out in the court of law?
That,
Huh?
that, my lord,
If you cannot have the political drive, the political will to do it, then forget it.
I
not
don't
a
think,
matter
my
of
lord,
right.
because it's purely legal issue, my lord, here.
Hmm?
Legal issue, my lord. Only whether 160 suppose one is satisfied or not. If that is satisfied, okay, my lord, nothing. They have justified it by filing this affidavit, saying that they have also some lost some land document, etc. They are suffering. Whether those things are, whether it comes within the.
My lord, a detailed procedure was undertaking a cabinet pursuant to decision in the cabinet, a cabinet subcommittee was constituted. The committee has, my lord, I have given full detail of the records, my lord, because the records are voluminous. My lord, a full procedure has been adopted to find out to fulfill the requirement of section 160 of the Assam Land and Revenue. I have annexed all these documents. Cabinet subcommittee meetings held from time to time on several dates for 2-3 years. Thereafter, it was entrusted to the disaster management department.
This affidavit is filed on behalf of respondent number 5, 6, 7, and 8.
They are
Who are the respondent?
They are, my lord, they are also subsequently implemented because Gorkhas were also included. So they were subsequently implemented. They have filed an affidavit. I am not on that, my lord. Your lordship may kindly have our documents.
Okay, today what is to be done?
The
I
your
think
lordship
your
may
lordship
dispose,
will
my
always
lordship may dispose it of. I have produced the record. records will justify that we have fulfilled the requirement of section 160 of the Assam Land Revenue Bill. Nothing is recorded. There are 2-3 decisions Supreme Court which says, my lord, in the matter of policy, court will not enter deep into the matter as to how it. Well, we have undertaken a full procedure. I have given the records, my lord.
No, that I am not disputing, my lord. If your lordship find that section 161 is
Yes,
satisfied,
yes.
I have nothing to say, my lord.
Lordship may-
Lordship may dispose.
Lordship
This
may
will
just,
require hearing. We'll not do it today.
otherwise,
Mr. Chaudhary, there is nothing in this case. You take a chance later on.
my submission will be,
This matter should not be entertained as PIL.
my submission.
When I give to your lordship, my lord. your
My
lordship-
submission, will Lordship may dispose it of 2 days, and Lordship may just have a look at the records, Lordship will be satisfied right
No,
now.
but it is his petition. If he, do you want it to be disposed of?
Yes, yes.
But if your lordship finds that this is
Yes.
satisfied, 160 subclause 1 is satisfied by the affidavit, your lordship may
That
dispose.
will require a hearing.
My lord,
That is up to because time.
my lord may record only the procedure that we have undertaken. The records will produce based on that, Lordship may dispose it of. There is nothing in the petition, absolutely
Matter has
motivated.
Come up for admission.
Or your Lordship may admit it and then fix it for hearing, my lord.
Pleadings are complete.
My lord.
Yes, yes, very important.
Mr. Majumdar, this bench is for 2
I have
days.
understood, my
Keep
lord.
that
Lordship
in
may,
mind.
as I have submitted, my Lordship may
Yes, your lordship, my lord.
admit it
This bench is
and fix it
very-
for hearing in the evening.
But prima facie, I don't know what my learned brother will say. Too many issues fall in the realm of the legislature, the assembly,
My lord.
the executive, not executive, the legislature. Is being straight away brought to the High Court and PIL notices are being issued. This is a weapon which is to be used very sparingly,
My lord,
really
this-
for the benefit of people who are totally marginalized, who have no means to espouse their cause. Not in these manners. These
And-
are issues we frequently see it happening, people making
This
statements
is
in
a
the media.
purely political and it's a policy decision, my lord, based on section 160 of the Assam Land and Regulation Act
Chapter-
and 2019
Chapter-
land policy.
But chapter 10 was added only for protection of these people, right? Now if somebody else also given, it will negate
And
the
they are all,
purpose for which chapter 10 was included.
and they are all indigenous
The purpose
people.
will negate.
You're right.
Right.
What you are saying is correct. Still will dismiss it. Whether it negates or propagates, these are matters for the assembly to consider. The lawmakers to consider. Because
In
there
the
are,
light of the provisions of the law.
all right, heard Mr. H.H. Chaudhary and Senior Counsel, assisted by Ms.
Decca.
R. Dekan and counsel for the petitioner. Also heard Mr. D. Majumdar and Senior Additional AG Assam appearing for the respondent numbers
State respondents, man.
1 to 4. Mr. R.P. Sharma and the Senior Counsel assisted by Mr. M. Bora is present on behalf of the private respondent numbers 5 to 7. Full stop. It is submitted at the bar that the pleading, 5 to 8. Pleadings are complete. Since the projection made in the PIL seeks to raise certain legal issues, the matter, in our opinion, would require detailed hearing. As such, admit the PIL. Since the parties are already represented, no formal notice is required to be sent in this case. Register to list this case for final hearing in legal course.
Deeply object.
Item 4.
Yeah, Lord. This is a matter pertaining to consideration of the validity of a domestic inquiry. A single judge on the basis of Supreme Court judgment, the copper engineering says that it's not amenable to rejurisdiction. Our only contention is before the Honorable Court is that since is a lack of jurisdiction committed by the learned tribunal and exceeds its limit, so therefore the copper engineering not applicable. This is the contention of us.
It will take some time.
Yes, that therefore it is not a regular ban. So therefore it's maybe fixed on 24th, my lord. My only difficulty is that the lower court matter, tribunal matter is fixed on 11th. So that we may take a adjournment and matter may be fixed on 24th.
Issue herein is not so complicated. Only thing is that
Now you see, it's not,
On the request of learned counsel for both the sides, let this matter be listed again on 24/9/2024 as a fixed item.
And the lower court may not be pass any adverse order.
You seek adjournment then.
Lord.
For hearing item 5.
May I please your lordships. My lord, I am for the appeal in my. My lord, writ petition was filed by the respondent number 1, my lord. Matter relates to the appointment of distributorship of LPG gas cylinder. My lord. That issue is relating to the writ petition that my lord, whether a co-owner can list out a particular plot of land in favor of me, my lord. And in order to fulfill that criteria for appointment, my lord, a list was executed in my favor, my lord. And that was challenged by the respondent number 1. And my lord, Honorable Single Bench, my lord, set aside my selection on the ground that landowner is not absolute owner, but a co-owner. Now the question is, my lord, whether a co-owner can execute a list for a particular plot of land to the extent of his share, my lord. My humble submission, my lord, according to section 44 of the transfer of property of my lord, a co-owner can transfer or list out to the extent of his share, my lord. And this is my only contention, my lord. And regarding my lord and supplement, my lord, I have my written argument along with. How much time will you take? Not more than my lord. This is very little submission, my lord. Right. But we'll not make it part of. For any reason, if it gets adjourned, then you have to start it from there. If this bench may not be available next. This is my written argument, my lord. How long will you take?
My lord, no, my lord, that it is apparently clear, my lord, that section 44 will not come to in this here. On the date of filing of the, my lord, last date of the filing of the, my lord, tender, my lord, he is not eligible, my lord, and Lanet Single Judge deal it very clearly, my lord. And that's why, my lord.
Right. Let us read the order of the single judge. Yes. Which page? Page 98, my lord. Para 16, my lord. With the findings. Yes. May I read, my lord? And lordship may kindly look into page number 40, my lord. That is the criteria, my lord. Page number? Page 40. But you have said before that, my lord. Follow up. You're taking the code to 98, then refer. 98 is the findings, my lord. Where does the order start?
94.
94, page 94. The whole order.
94.
You take your seat, please.
My lord.
Where is clause 6.1? Which page?
It's clause 6.1, my lord. Page 40, my lord.
Page 42.
40 of the paperwork, my lord. Put 6.
Yes, so the requirement of the tender was that the applicant should be either owner of a shop or a plot of land.
My lord.
So your client has submitted the tender
Yes,
by relying upon a lease deed
yes.
entered with this man. His name was subsequently included in the Jamabandi as a co-owner.
No, my lord. Yes, my lord. It is.
Yes or no? You
Yes.
can't say no, but
Yes,
yes.
yes, yes, my lord.
That kind of submission you
Yes.
can't make in the court.
Yes.
Yes. Either
Co-owner.
Yes or no.
Co-owner, my lord.
Yes. So Leonard single judge is held that first of all, there is nothing to show that on the last date of submission of tender, this man had any title over the land. Second thing, being a co-owner, he would not have the authority to enter into a lease without the consent. That part has not been mentioned clearly, without the consent of other co-owners. That is the correct position in law. What is wrong about it? What is wrong about this view?
My lord, in this regard, my lord, I have relied some.
You rely,
judgment,
but
my-
first tell us what is wrong in this view of the learned single judge. Can a co-owner unilaterally enter into a lease? Lease is a temporary transfer of interest.
He can transfer to the extent of his share, my lord, not more than that. My contention is that, my lord. A
But-
co-owner can transfer his right to the extent of his share, my lord.
Transfer in what manner?
Transfer, my lord, title, my lord.
But he submitted, my lord, he has a, my lord, absolute owner of the land, but he have filed a certificate, affidavit, my lord. Although he is a co-owner, but he submitted, my lord, false information to in the tender record, the absolute owner. Your lordship kindly see absolute owner, my lord, that is absolutely wrong information, my lord. If there is a wrong information, my lord, there is a procedure, my lord.
Let it finish.
My lord,
Plus, this is a tender of 2014.
my lord.
It's still going on.
Still, my lord, law of lot not been done. The law, it is by decided by law of lot. But second law of lot is not been done. There is a stay order, my lord. And in fact, very interestingly, my lord, they did not file a affidavit in the land before the land single judge, my lord. They did not mean file, my lord.
Page 122 is my lease agreement, my lord. Everything on record, my lord. I have nothing to submit any more than record, my lord. And before that, my lord, page,
Page 122.
yes, my lord. 122 is the lease agreement. And it is correct, my lord, page 124, it is mentioned as he is the absolute owner.
Absolute owner. That is,
That I cannot deny, my lord. But my lord, before that, my lord, page 119. This is the mutation order, my. lord.
So that you agree that this was false, it was not correct. He was not the absolute.
No, my lord, I am,
Yes.
and my lord, authority investigated the matter and my lord, they've found that I am eligible, my lord. 103 is the affidavit in opposition, my lord.
No, you're eligible means we are only concerned about whether this is a valid piece of document which your client could have been relied upon. That's the only thing. If the answer is negative, then your client is not eligible. If it is positive, then yes. And a single judge has held that no, this document was not correct. First of
My
all,
lord, it is lease agreement, my lord. Drafting of lease agreement, my lord, depends upon. It is not on the discretion of my client, my lord. That was drafted by somebody else. Absolute means, my lord, a particular plot of land, not the whole land, my lord. And my lord, it is correct that, my lord, he leased out within his share, my lord, not exceeding his.
how
share.
much was his share?
Condition to find.
My lord,
And he has.
one kotha 15 lesser total land, my lord. And there are 5, my lord. 4, my lord. 4.
He's saying 3 kata. 19 lakhs.
It says, my lord, he is in possession of the particular land, my lord, and this particular. So, my lord, on my, he is 19 less.
Subsequently, my lord, whole plots of land, my lord, be situated in my name, my lord, subsequently, my lord. Not at that time, my lord. And that I brought into the record by way of affidavit, my lord.
All right.
My lord. Affidavit dated, my lord,
What is your submission?
22/8/2022 is the affidavit, my lord.
Mr. Seke, what is your submission? What is your submission?
Well, my submission, my lord, there is nothing irregularity in selecting my application, my lord. That's because, my lord, lease agreement was executed in due procedure with the permission of the deputy commissioner to the extent of share of a co-owner, my lord. And it is under
So
section
it is undivided share.
undivided share, my lord.
You say there is a judgment which permits leasing of undivided share.
My lord, they are contention that I am not the possessor of the definite particular plot option, and there is a
So
judgment.
you please answer one simple question.
My lord,
The leaser has leased out a definite area of land to your client.
yes, my lord.
On what basis he is claiming that definite area if the land has not been partitioned? Say this is a land
Right.
1 biga.
Right,
There are 3 persons who are owner.
yes,
The land is not yet partitioned. Correct.
Yeah.
So that means this will be divided amongst 3 persons,
yes, my lord.
but only at the time of partition
Right,
will it be clear who gets which part. Right.
my lord.
So somebody says, you do the partition later, but today that corner is mine, I'm going to lease out. Is it permissible under the law?
If, my lord, that portion of land is not exceeded to his share, my lord, it is permissible.
Show me the judgment. Show me.
My lord, section 44 itself.
All right, section 44, yes. Transfer of property.
Transfer by one co-owner, where one of 2 or more co-owners of immovable property legally competent in that we have transferred his share of such property or any interest therein. The transferee acquires as to such share or interest, and so far as is necessary to give effect to transfer, the transferor's right to join possession or other common or part of enjoyment of the property and to enforce a partition of the same, but subject to the condition and liabilities affecting at the date of transfer, the share or interest so transferred.
All right, anything else?
This is my humble submission. All right.
Yes.
My lord, that regarding that OCR, my
You are
lord,
appearing for the rate petitioner.
yes, my lord, rate petitioner. So, my lord, that plea they have not even taken in the before the single judge, but I am not on that, my lord. Here in this case,
Look,
there is
44 is different.
Yes,
44 has
different.
nothing to do with
a different, and that cannot be even, my lord, cannot be transferred. Cannot be, my lord, your lordship, there is judgment of the Supreme Court, my lord. Very clearly, my lord, para 17, without, my lord, partition, that cannot be transferred. Para 17, my lord, your lordship, kindly see. About us, about us. Same.
That's correct.
So, my lord, your lordship, kindly see, my lord, he filed an affidavit.
Yes.
Para 73, page 73, your lordship, kindly see. Page 73. That is the affidavit. That is the affidavit, my lord, he has submitted. Whereas the name of the lessor is the absolute owner of the land measuring so and so, so and so. But that is not a correct statement, my lord. Because at that point of time, he is not the absolute owner of that particular land. He's showing himself as the absolute owner, he, my lord, at affidavit. And when, my lord, false information is given, then there is a provision how to deal with. Your lordship kindly see that page, false information. Page 1, page 34, my lord, your lordship kindly see. That is the advertisement, my lord. And very clearly, my lord. Clause 11G. Clause 11G, my lord. What here are you? Page 58.
This is hardly legible. Clause 11.
Yes. Clause 11G, my lord.
Where is clause 11G? Which page is clause 11G?
Page 34, my lord. 34, but that is, my lord, then your lordship kindly see page 58. It will be clear, man. Page 58. Page 58, man. Page 58, furnishing of false information. If any statement made in the application in the document that can close here it or a subsequent submission in person to so mission so is liable to be rejected without assigning any reason, my lord. So that is there, my lord. So, but that was not done. They try before this honorable court, and this honorable court allow our petition, my lord. It is crystal clear at the admitted position that at the time of filing submission, the last date of submission of the my lord tender, he is not the absolute owner, the is not the absolute owner, and he is not as that's why he is not eligible to my lord participate in the tender process. That was the finding of the learned single judge, my lord.
But this clause 21 aspect was not dealt with by the learned single judge.
Oh, my lord, although it is not deal, my lord, but petition is, my lord, allowed.
You have for respond number?
1, my lord.
And Mr. Bhattakur? Yes, what do you have to say? So, Mr. Mahanta, anything else?
Before going further, my lord, kindly see the page 77 from where the problem starts, my lord. The who are the co-owner, my lord. One of the co-owner has been filed a title suit, my lord, for declaring his title, my lord.
Then
Please.
why have you cleared it? Why have you cleared? What is the stand of your client
No.
here?
Our stand is the petition, the lessor, my lord, has a exclusive possession about the land, my lord, which we required, my lord.
Hmm.
In-
Exclusive position over the entire land.
No, my lord, about three kotha tell us, my lord. It is in the plane itself, my lord.
Ah.
Page 78,
So
77,
where
my
is the
lord.
document to show that he has?
That's page 77A, my lord. Para 3, my lord, of the plane, my lord.
So he has stated that he has absolute possession, therefore he has absolute.
Yes, my lord. The last part, they are occupying and.
Serious about this submission. Tomorrow somebody
I'm-
comes and say, I am the owner of Guwahati Airport. You treat him as owner.
Since the affidavit has been filed by the repetition, my lord, I cannot go beyond that, my lord. These are stand, my lord, in the repetition, my lord.
So there is a suit between the co-owners.
Yes, my lord.
And what has happened? Suit has been decreed.
He's been decreed, my lord. He got his share, my lord. One, where there is a total now 2 bigger, my lord. In the partition, my lord, he got only the original, my lord. Plaintiff, my lord, got only 1 katha 10 less, my lord.
When is the decree?
But 50 here not annexed, my lord. And my lord, in the plain, my lord, the plaintiff himself is there that all the
What is the date of the decree?
16, my lord.
Which was after the sanction of the minor tender.
Yes, madam. 4/6/2015, madam. It was declared on compromise, madam.
So on the date when they,
It was not.
so now you issue fresh
Yes, madam.
tender and if he is eligible on this
Yes, madam.
same.
That's why I am
now
submitting,
the-
madam.
Huh?
Except this, madam, the records, I cannot go beyond, my lord.
Correct. So if you all agree, let them issue fresh tender and.
No, but he said,
It's a go for it, redraw.
redraw, my lord.
Huh?
Redraw.
Redraw.
Yes,
Redraw
madam.
among the other tender, minus him.
Yes,
No,
my lord.
That is the law, man.
Uh,
The tender.
that may not be possible.
Page 53, my lord. Clause 12, my lord.
Page 53.
Yes, madam. Condition for redraw, my lord.
But more than nearly a decade has gone now.
Yes.
Why should there be a redraw? Let them issue a fresh advertisement.
But if when this clause is there, redraw and my lord, because of the litigation that is my lord. And in fact, from 19, they are enjoying the stay order.
And I am not taking time, my lord. Both the party has taken time, my lord. Record shows, my lord.
Draw of selection should be held again for the remaining eligible applicants of the.
ऐसा नहीं हो रहा
That is the law. Is 53, my lord, first. Well.
So which of the three conditions are met here for redraw?
Rejection of selected candidate due to the finding of the.
No,
Values. LOI within the front. Yes. Although there is no court, there is no mention about the court question, but court finding is that he is not eligible tender, he is not eligible tender.
Mr. Mahanta, you are saying that the writ appeal should be dismissed and there should be a redraw.
Fine.
For redraw, these conditions will have to be fulfilled. Which condition is fulfilled here?
Then, my lord, page 51 will come into force, my lord. Page 51, my lord, clause 9.
Please first
So
respond
there
to
is none, my
this.
lord. But my lord,
Listen, the learned single judge has set aside his
Yes, madam.
Selection.
Yes, madam.
LOI was not given to him.
Yes, madam.
It was set aside.
Yes, madam.
Very well. Then directed that a redraw has to be held.
Yes, madam.
That redraw, holding of redraw has to be in accordance with the terms of this.
But LOI has been issued, madam, 3/5/2016, madam.
LOI had been issued to
Issued,
him.
madam.
Okay, then it comes within 12B.
Yes, madam.
LOI had been issued to
Yes,
him.
madam, 3/5/2016, madam.
Is it so? LOI was issued.
Yes, madam.
Nobody seems to know anything. Choose a date in October, then we can fix it again. Come prepared.
My lord, the last page, my lord, 133, my lord.
133.
I was asked to deposit some sort of amount, my lord.
We are asking again and again, has LOI been issued? Except answering that, you are telling everything else. What you were asked to deposit. Why don't you give a straight answer? Was LOI issued to your client?
No, my lord, it is award of application. I am delaying this.
LOI issue, please. Yes, 90,
Very difficult to decide cases quickly. Absolutely poor level of assistance. A simple question has been asked, is the LOI, has the LOI been issued?
Madam, page 104, madam.
To answer that.
Madam, 104, madam, kindly see our affidavit, madam, we have stated, madam. Para 9 of our affidavit, madam.
Was the LOI issued or not?
Yes, yes, madam.
Where is it?
But page 104, madam.
He doesn't know whether it was issued. He is the appellant's counsel. He doesn't know.
Where are you?
LOI was issued on 3/5/2016, madam.
Where is the LOI?
Page 9, para 9, madam, 104, madam. The last sentence of the para 9, madam.
Where is the LOI?
But
Where is
oh,
the LOI?
it was not annexed, madam, but we have
Where
stated
is it?
LOI is issued on
Here it
3/5/16, madam.
We'll see it first, then pass in order. Materials are not complete. Now, unless the LOI is issued, there is no question of redraw, Mr. Mahanta. You have to understand that. There are three grounds mentioned. None of these three grounds are satisfied. And there is a direction for redraw. How do we deal with this now without, so he is saying no LOI, you are saying LOI. You are saying so because somebody has written it in a petition. Are we to rely on these things?
LOI, yet condition mallet contained in the, for redraw, madam, the LOI is withdrawn from the selected candidate. But here in this case, might say this.
Where is the LOI?
But since the affidavit is filed by the official, our office, madam.
October or November? When do you want the matter to be listed? See how the time of the court is wasted in this manner. This is a contentious issue. How do we give a finding? Whether it should be a case of, if no LOI is issued, no question of redraw. If LOI has been issued and withdrawn, then only redraw. This is the most crucial issue here. And that vital document is not there, no instruction is there. But so it's a learned council.
Can it be on next week, madam?
Huh?
Next week, madam, I'll try to get it because.
On the request of learned council for the parties, that this matter be listed again in the next week.
On 17, madam.
Yes, I don't know who it is.
Item 738.
Sir, item number 8. Well, item number 8 is of Arunachal Pradesh. And rest are of the state of Assam state. My lord, I can start the case, but this is regarding the validity of the Assam Anti-Tax Act.
Will not keep it parted.
My lord, I don't think that
Because
It was in 2021, it was heard at length, CAB. Then both the honorable judges were either transferred or elevated to the Supreme Court. Then
understand
again
this.
it was heard. No, I am, because in 2 days it cannot
What
be
to do?
completed.
This bench is only for 2
Yes,
days.
Lordship, therefore it is no point, Lordship, starting it.
See, we want to decide cases quickly, but somehow or other, something, just now you saw.
Yes.
I was about to dictate the judgment. We are not discussing about another matter, but you were there.
Because I think,
The
Milord,
most crucial document is the LOI here.
on the last occasion when the matter was
And
heard,
two conflicting opinions.
How do you give an opinion as a division bench? It goes directly to the Supreme Court. These are the problems we are facing when we want to quickly
when
decide.
Lordship wants to dispose of.
The earlier round also, it was almost day-to-day hearing for 10-15 days. It is a lengthy matter. My friend
These
will agree.
cases should be actually given to special bench.
Lordship.
No, that-
I thought today it is a special, but that's why
No,
I thought that was my impression.
the Honorable Chief Justice is
My
not
lord,
in Guwahati.
Only for 2 days.
So that is what we would presume because this is the division bench one. Division bench one is presided by the Honorable Chief Justice. And his lordship will be back on Monday. So
So
what
either
is-
in the special bench or Milord in the regular bench, Milord regularly, then it can be taken up.
there should be special bench of judges who have no possibility of going out soon. That is the safest way.
Normally, Milord, whenever the matter has been taken up, either the judge has been elevated or
And lastly, it was
Last one.
superannuated, the last one.
last one. So this is the third time now we are coming. So,
What do you suggest?
Milord, either elevated or something may happen, Milord, nobody knows.
Then it is better to go to division bench one, regular division bench one.
Very good.
No, because you
Well,
cannot conclude it
It will not be concluded.
Let it be after 2 weeks, Lordship. Let it-
after 2 weeks. All right. Dr. A. K. Saraf, Learned Senior Counsel, assisted by Mr.
N.N. Datta.
N.N. Datta, Learned Counsel, appearing for the writ petitioners in this series of writ petitions, as well as Mr. D. Saika. You are appearing as AG?
AG, Lord.
Learned Advocate Kiran Assam,
In,
assisted by-
except item 8, rest I am there.
assisted by Mr. B. Chaudhary, Learned Standing Counsel, Department of Tax. In this series cases, except item number
8 Milord is of Arunachal Pradesh. Milord. Seven. Milord.
except item 7, you put the case number. And Mr. A. Chandra, Learned Senior Government Advocate AP, appearing for the respondents in item number 7, have all submitted in tandem that this matter would require lengthy hearing and therefore lengthy hearing which may not be possible today. It may require lengthy and day-to-day hearing which may not be possible before this bench, and therefore these cases be adjourned for 2 weeks. Having considered the submission made at the bar and after going through the records of these cases, we agree with such submission of the Learned Counsel for the parties. Registry is therefore directed to release these cases again after 2 weeks.
Deeply obliged.
In fact, I would suggest, please make a mention before the bench
Lordship.
that it should be given to us
Special.
special bench so that the matters are heard in
My-
one go and a judgment is.
The
Because
matter-
only hearing is not enough, a judgment also has to come. And if these benches keep breaking, it's not furthering the
yes.
cause of these matters.
That's correct.
These are very technical, specialized cases.
And the matter, in fact, with other matters mixing up and sometime coming for half an hour, 45 minutes, that will not solve the
No, it
problem.
doesn't, because for
It's a full-length hearing.
bench also to
My-
start absorbing the issues and the arguments, it requires a bit of preparation.
Lordship, absolutely correct, Lordship.
Suddenly-
We'll make a mention to that.
my-
By the time
Yes.
matter is heard halfway through, then you get a feel of the case,
That's
which is
correct.
not good. At least that's what I feel.
We try to mention it.
It's better, whoever the bench is,
My-
which should be
Well-
tied up to a bench. All right.
I'm obliged.
God bless you.
This writ petition arises out of an order passed by the Central Administrative Tribunal. So
Yes,
it will take some time, my lord.
it takes some time.
My lord.
When do you want it?
If it is 26th of September.
26. Mr. S. Chakravarti, Learned Counsel appearing for the writ petitioners, as well as Mr. S. Not Learned Counsel appearing for the respondent. They have both made a request before this court to post this matter for hearing again on 26th of September 2024. Having regard to the ground on which the prayer is made, comma, the same stands allowed. Registered to list the matter accordingly.
Item 41. 41 and 43.
It is not said is not there.
My lord, my CDF is on the way, my lord, it's coming, it's on the bar, my lord. I'm not in the matter, my lord, but just not in the matter. The matter.
Lordship, there are two matters. One matter is heading by Mr. K.K. Monto, Lordship.
Wait, but if you want to argue, you argue. What is this case about?
Regarding validity of degree, BS engineering. It is actually it is not a valid degree as per UGC Rule 22. Lordship in a single bench, Lordship kindly goes for the single bench order.
Lordship, I may pray for that this matter will be come before the regular bench, Lordship.
No, no.
Because it needs some hearing, Lordship.
No, no, my lord, that.
We'll not keep it part today. If it
Yes.
is not completed, then it will be released.
Yes, my lord.
But the appellants are not there.
Other Montessori, Montessori.
Yes.
Visual.
The next is.
Let us see. Let the other councils come if you want.
Item 46.
The other side is not here. This writ appeal, my lord, is filed against an order by which the Learned Single Judge has, my lord, interfered with the quantum, my lord, and quantum of punishment, you know. And against that we have filed, but my lord, the other side is not here. Lordship may take it to some other day.
Who's the other side?
Mr. N. Dhar was there, my lord. It will take some time. The front should be, I do not want in absence, my lord.
Mr. P.K. Roy, Chaudhary, Learned Senior Counsel. Mr. P.K. Roy, Learned Senior Counsel for the appellants is present. However, none is present on behalf of the respondents. Although the name of the counsel is shown in the court list. Considering the nature of controversy involved in this appeal, Mr. Roy submits that this matter is required to be heard in presence of the Learned Counsel for the sole respondent. In view of the above, and considering the fact that the respondent's counsel is absent today, we are left with no option but to adjourn this matter for 3 weeks, list accordingly.
Finding matter item 41 and 42.
On the request of Learned Counsel for the appellants, after 2 weeks. List after 2 weeks, the appellants counsel after 2 weeks. This matter. Give the present.
For respondent number 3.
Give the so and so present on the request of Mr. Sutradhar. That these matters be listed again after 2 weeks for hearing. The appellants are not there, so we have after 2 weeks.
Yes, Lord.
After 2
And
weeks,
a date may be given, my lord.
take a date after 2 weeks. She'll give a date after. Yes.
Lordship.
Date will-
Appeal again date.
At September 81 again.
September was lost.
After 2 weeks, I no. Sorry. After 2 weeks.
19. Nineteen. Cover the 19 or